Okay, I'm back with a continuation of the lecture on Chapter 1, and we finished off talking about the Regina versus Dudley Stevens case specifically last class, and we'll get into the development of the law since then in this lecture. But before I do, I wanted to quickly make a comment, and that is a couple of comments. Number one is in the textbook, you will note in the inside cover and the disclaimer section, it will either say, make no reference to it being the first printing, which means it is the first printing, or it will say second printing, or it will say third printing. All right? Now, what's the difference? Well, the first time the textbook came out, we did it in such a rush that there were a lot of typos and spelling errors, for which I apologize, but it saved students about $85, so it was for your benefit. Since then, I came out with, rather than doing a second edition, which would mean that you would not be able to sell your old textbooks and recoup some of the cost, I did a second printing. And in the second printing, I repaired those spelling and typo errors. So if you get a second printing, you know why it says second printing. Then in the third printing, after reviewing my textbook and after using it for a couple of terms, I realized that there were some things I could have explained better. I did not delve into the rule of law sufficiently in the first printing and the second printing, and so I've amended that in the third printing. I also amended an error in a diagram in the second printing, and I also added a different perspective on the three types of union disputes that you can have. And rather than do a second edition, which would then prevent you from selling your textbooks and recouping some of the money, because that's of concern to the students, I did it this way. Now the third printing is the way I want it. If you have a first printing or a second printing, then what you'll have to do is go on to eLearn to a document that looks like this, and what it is those pages that have been changed so that you can use those earlier printings and this material and come up with the right information for the textbook. Okay, that's all I wanted to say about that. Now, one comment about Regina versus Dudley and Stevens. Just at the end of the last lecture, I was talking about a hung jury. And from a historical perspective, hung juries were considered to be bad in 1884 and earlier. And what happened is, if there was a hung jury, the jury was not dismissed. They were all put into a cart and dragged through the city of London, where all the people would throw rotten tomatoes and other rotten vegetables at them. And then they would go back, and that would be an encouragement for them to actually come up with a unanimous decision one way or the other. All right, now we're heading into the development of the law since 1884. We saw that in 1884 there was one provision in the Criminal Code of England which said if you killed someone, it was murder, and you should be taken from the place of justice to a place of execution and hanged by your neck until you are dead. Well, that's harsh, because there are extenuating circumstances, as there was in this case. But other than appeal to the Queen, which very few of us could do, you actually had no recourse. Okay. Now, the appeal to the Queen in Regina versus Dudley and Stevens was because this case was really particularly important for their merchant marine and their navy and their empire. Okay. But most of us don't have those sorts of benefits that we can rely on in order to have a death sentence commuted. So since then, obviously, the law has developed. And on slide 20, we see a reference to the Criminal Code of Canada from a number of years ago now, so there may have been changes. I don't practice criminal law, and it's not terribly important that we have the absolute up-to-date criminal code at this particular point in time, because it's the idea of how the law has developed over time. So in section 22, on slide 20, it talks about a person commits homicide, meaning kills someone, directly or indirectly by any means if you cause the death of a human being. Homicide could then either be culpable or non-culpable. Culpable homicide is a crime. Non-culpable homicide is excusable. Well, what's non-culpable homicide? There was a case in Ontario years ago where a woman came into her apartment, was grabbed by the neck by someone behind her and was being dragged into the bedroom, and she was being choked and her clothes were being ripped off her. She reached in the purse, pulled out a gun and went and killed her assailant. Now, she was charged with murder and it went to court. And obviously she was defending herself. And the Crown prosecutor, or the Crown Counsel in this particular point in time, had this new section and didn't know where the parameters fell, like what was culpable, what wasn't culpable. So they brought this case partly to clarify that issue. And the judge in that case said, well, it sounds like self-defense. And the Crown Counsel said, well, she used more force than was reasonably necessary. And the judge said, well, I don't agree with that because, well, she was being choked and she was losing consciousness. Did she have to wait till she was passed out, raped, and perhaps murdered in order to know how much force to use? So the perception was that she was under the impression that her life or her body was at risk, and so the force was necessary, and that was deemed to be non-culpable homicide. All right. So non-culpable homicide is not an offense, but culpable homicide is, and it can be considered to be either murder or manslaughter or infanticide. Let's take a closer look at those. There are classifications of murder which are no longer specifically in the criminal code, I think, but the concepts are still there, particularly in precedent. One of those is that murder is either in the first degree or the second degree. What's the difference? Well, let's say I have a class where I already have 40 students and there's a couple of forced registrations and now I'm at 42 and the fire marshal is upset because there's too many students in the classroom and the department is after me and everything. And so what I have to do is figure out how to reduce the number of students. So I take out a scoped rifle at the end of one class and I look out the window and the students are going out to their car. I adjust the scope, I look through, check the weather, and I shoot 2 of the students. Well, that is obviously planned and deliberate, and so that would be first-degree murder. Second-degree murder is when you kill someone but you don't intend to. Okay? Let me give you an example. There's my class. There are 40 of you sitting there. And in walks some big galoot, and he walks up to the front of the class and he says, all right, everybody, this is a robbery. Give me your money, your purses, your cell phones, and your jewelry. What's wrong with that picture? Well, what's wrong is there's probably 3 or 4 really big, beefy, strong guys in the classroom who would get up, walk to the front of the class, and beat up the assailant, right? So the robber doesn't do that. He walks into the front of the class and he goes, with a shotgun, he goes, all right, everybody, this is robbery. Give me your wallets, your money, your purses, and your cell phones. Well, now those 5 beefy guys aren't going to jump up and run to the front of the class, right? But let's change the scenario slightly. Sitting down in the front of the class is Daryl Smart. Daryl is a very nervous person. Okay, he drinks too much coffee and he's got a nervous personality. He's always fiddling with his pen and he's rattling his papers and his knees are going up and down. And in walks this guy and he goes, all right, everybody, this is robbery. And the guy goes, ah, and you shoot him, right? Because, you know, armed robbery is a stressful way of making a living. So the person didn't mean to kill Daryl Smart. So for some reason, our government thinks this is not as severe as, you know, when I shot a couple of people heading out in the parking lot. Because you intended to rob them, you didn't intend to shoot them. So this is murder in the second degree. whether you agree with that or not is irrelevant because that's the law. If you don't agree with it, then it's time to get onto your member of parliament. It's time to run for office. It's time to get people to sign petitions, something to change the law. But that is the law. So, if it isn't murder in the first degree and it isn't murder in the second degree, what is it? Well, it could be manslaughter. Okay, manslaughter is in section 232, and it says culpable homicide that otherwise would be murder may be reduced to manslaughter if the person who committed it did so in the heat of passion caused by sudden provocation. Oh, well, let's think about that. Sudden provocation. There was a case in Ontario where a father goes to watch his son play hockey, and his son's just a little kid, right? And there the son's sitting on the bench, and the coach is behind the bench, and he's sending kids out onto the ice and everything. And finally he gets around to sending this little kid onto the ice, and the little kid walks out the gate and goes, oh, falls flat in his face and flounders around like a fish out of water, and gets up and slips and falls down, and so the coach gave the kid a chance. So then he benches the kid, puts him back in the bench, and the father sitting behind there gets really irate. Now this is a real case, okay? Gets really irate, and he starts yelling and screaming at the coach and saying insults and and he keeps it up and he keeps it up until finally the coach says, "Look, would you mind shutting up?" Okay, this is sudden provocation. The guy jumps over the bench, starts beating up the coach, beats the coach to death. Now, I always throw in some black humor because, the father's doing this and he looks at his son. He says, "Okay, son, when you get to the NHL, this is how you do it." I'm being facetious. That didn't happen in the case. But the fellow did beat the coach to death. And rather than being charged with murder, which means it was planned and deliberate because he had to jump over the bench and actually beat him up and not stop, they considered it to be manslaughter because there was sudden provocation. I don't agree with that one. Maybe my neck is getting as red as my sweater, so I'm becoming more of a redneck, small c conservative person. But anyway, that's how the courts decided it should be done. So that's considered to be less serious than the scenario. The next scenario is when you cause death by criminal negligence. Now, criminal negligence is when you didn't have sudden provocation, it wasn't planned and deliberate, you didn't commit the murder in the course of committing another crime. This is a scenario that relates directly to drunk drivers, all right? You get behind the wheel of an operation vehicle and you are intoxicated, there's no way you should be driving. Well, you're just being negligent, okay? And so the government thinks that this is less severe of a situation than even the manslaughter one. And so the person, is driving along and he accidentally kills somebody. Well, it's an accident, it's negligence. And so again, the punishment is considerably less severe. Now, in BC, there was a situation where some young people drank way too much. One of them got behind the wheel of an automobile and ran down a couple of senior citizens standing at a bus stop. And they were given house arrest for not a very long period of time. I took great exception to that because I don't think I'd like to be under house arrest. I mean, all we have to do is look at the frustration that people are feeling right now, being asked to be confined to their home because of the COVID-19 pandemic. And yet, I don't feel it's any tremendous punishment. So let's see, you're under house arrest, well, you can wake up Monday morning, you can shower and shave and go to work, okay, and come home at the end of the day, and you have to stay in your house. So that means you cannot go to a restaurant with your family or friends, you cannot go to the movie show, you can't go to a football game, a hockey game, you can't do all those things. And you go to work Monday, Tuesday, Wednesday, Thursday, Friday, and then on Friday you may or may not be required to then go and report to a facility and be locked up on the weekend. Or you may just be allowed to stay at home and not leave. Now you wear this ankle bracelet, which is extremely difficult to remove, and if it goes out of the house, beep, 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 then the police know, and you're in breach of your sentence. But I don't think it's a tremendous amount of punishment because, I can't go to a restaurant. Well, I can order in food. Well, I can't go with my friends. Well, I can have my friends over and we can order in food. Well, I can't go drinking. Well, I can have my friends over at my house and drink. I can't go to a football game, but I can watch a football game on the TV. Well, I can't go to the movies, but I can watch movies on TV. And so I didn't think it was that appropriate a punishment considering what happened. There was also a Court of Appeal judge in Vancouver Island that took exception to this, wrote an article, it was put in the newspaper, and he said that the punishment was not in keeping with the crime. He was highly criticized, not by the people that read it, but rather by the legal profession, because that is inappropriate for a judge to suggest that another judge's sentence was incorrect. But he just had enough. So he was reprimanded, okay? Judges are not supposed to get involved in political or social debates. They are there to apply the law that is the law, and that's it, okay? So, but that's criminal negligence causing death. Some people get incarcerated. One of my uncles came back from World War II and had suffered mentally. And back in those days, they didn't know about post-traumatic syndrome. And so he received no help whatsoever. It was a strain on his family. He wound up being divorced. He drank. He killed someone in a car accident, and he went to jail for quite a period of time. And then he got out of jail, and he went to a halfway house. And since then, stopped drinking and has been an upstanding member of the community. So it was a mistake, an unfortunate one, but he paid a price. Why don't those young people go to jail? Well, because we don't have enough room in the jails. So they look for other possible ways of dealing with them. Okay, so that's criminal negligence. And then there's a really bizarre provision in our criminal code, and that's called infanticide. And that's in section 233 on slide 22. A female person commits infanticide when by a willful act or omission she causes the death of her newly born child, if at the time of the act or omission she has not fully recovered from the effects of giving birth to the child. That was in there, has been in there for years and years and years and years, and there were a couple of newspaper articles about this occurring, and then for a long period of time, there was absolutely nothing. And I took it out of the slides because I thought, well, okay, let's not waste our time on something that just, doesn't occur very often. And then, a month later, bingo, there's an infanticide article in the newspaper. They know it's a medical condition. There's no treatment for it. Probably because the pharmaceutical companies don't want to spend a lot of money on something that is so incredibly rare that they couldn't make any decent profit on it. Or maybe they just can't do it yet. But it's a chemical imbalance in the brain, I think. And so they have this provision, and the woman can actually be incarcerated for a period of time, or perhaps more likely nowadays have some sort of house arrest. So what these sections show is how the laws developed since 1884. Now in 1884, Canada was a colony of England, and so the Criminal Code of Canada was, in effect, the Criminal Code of England. Okay, so our provisions are the same. So we had one section which dealt with murder. One section dealt with killing someone. Okay, now we have all these sections. Okay, so what's that? 1884 to 1984. So 100 years or so later, we have numerous sections to deal with the same particular problem. Trying to provide justice as well as the law. All right, and I think that probably not even 100 years from now, but let's say 100 years from now, when somebody's studying in one of these classes and they look back and they go, oh my God, they had an infanticide section in there where they actually put women in jail for this mental disturbance, and of course there will be some sort of medical procedure so that this doesn't happen 100 years from now, and we'll look back and think, like this is the Dark Ages. Well, we're looking back at 1884 and saying that's like the Dark Ages. So you can see that the law is not a static thing, it develops. And this would be a really good question for Part B of my exam. And in a second, just let me look at the next slide here. Yeah, this is probably a really good place to stop and talk about my exams a little bit, because you're all eager to find out about those. So the law is developed. Well, on the exam I could put a question in Part B saying the law is not static, it is constantly developing. Explain using concrete examples from the course material. So you talk about Regina versus Dudley and Stevens, you talk about these sections in the Criminal Code and how the law has developed. All right, so let's stop right now and think about my midterm exam. You have a copy of last term's, the last time I taught, midterm exam, which is from the fall. And my format will be exactly the same this time around. There will be Part A, 15 terms and 18 definitions, and you have to match the terms to the definitions. And the nice thing here is that I'm not asking you to memorize the definitions, but I'm asking you to understand them. So let's say I put a term like false imprisonment in Part A. The actual definition from the leading case is false imprisonment is intentionally and unjustifiably confining another person to the total restraint of their movement by either actively causing their confinement or from preventing them from leaving the place in which he is. Well, no need to memorize that, but what you should really do is be able to look at that and say, okay, there's three elements to that. There's intentional, unlawful, confinement. Okay? And so you'll be able to look down the list, and I won't have one that says intentional confinement or one that says unlawful confinement when it's actually intentional and unlawful confinement. Okay, no, I'm just going to have one definition, which if you understand the material, you'll be able to make the connection. It's an open book exam, so you should be able to look them up. Trust me, you're not going to have enough time. All right? You should really know the material. Okay, so that's what you do. Well, how do you deal with Part A? Well, it goes back to the how to pass this course that I talked about. Index cards or a Quizlet on your phone. Term on one side, false imprisonment. On the other side of the card, intentional unlawful confinement. Now, if you do the card, wow, the night before the exam, whoopee. It'll help, but not a lot. What you have to do is do the cards early and practice them often. Okay? You go down to the cafeteria, you're waiting for your boyfriend. Guys are always late, right? Well, okay, you can sit there and you can go on your phone and you can text and you can, I got 28 likes on this picture and, wow, it's going to do you a lot of good in life. Hey, yes, I'd like this job, please, because I got 28 likes on this picture. No, you're going to get a good job because of your marks and your degree. Okay, so you can sit there and you can say, false imprisonment, flip the card. Okay, I know that. All right. So you practice them. So that's part A. Now part B is broken down into question 1, which will be a 10-mark question, and it will be something substantial, something with some meat to it, something like when we discuss arbitration in a while, something like the Constitution, which is just about the next topic, or something like torts in general, okay? And you will not know which one, what's coming in there, but even there you can prepare to a certain degree by knowing certain things that I consider really important, like the rule of law, like the Constitution, like arbitration. That's 10 marks. Part B is worth 30 marks. Part A is worth 30 marks, 2 marks per term. Part B, question 1, 10 marks. Then you have to choose 4 of 8 questions. So you have some choice here. These are 5 marks questions. One of the 5 marks questions could be the law is not a static thing, it is constantly developing. Explain using examples from the course. And I'll point out a couple of other examples as we go along. And that's part B, and you have choice. And I will point out potential part B exam questions as we go along, and you can actually, to a certain extent, prepare those in advance. Okay? I want detailed answers, though. And then part C is where things become a little more difficult. Part C will be a problem, a considerably long problem with all sorts of issues in there. And what you'll have to do is identify the issues and give me the related principles. We'll talk about that later, particularly when we're through torts and we do the tort problem. I will show you the best way to answer that question. So there's 2 aspects of this course, what you learn and what you have to give back to your instructor to get a mark. One year I had a fellow, he seemed incredibly on top of everything. He was always engaged in class, asking good questions, doing all the work. I only got a C+ in the exam, and I called him and I said, okay, Will, what's the problem? I expected a better mark. And he said, I'm lousy on exams. He said, I know what I know, and I know a lot about business law, thank you. But I don't write exams well, so I'm satisfied with that. Well, okay, all right. So there's what you learn, and then there's what you have to give back to me to get a good mark. So get into your instructors' heads, okay? Find out where they're coming from and what they think's important and what you can expect you'll have to give back to them, and then you'll get a better mark. All right, that's enough about exams. Now we're going to continue with the next aspect in the course, and this is some terminology that you want to know. And oh my gosh, look at the terms on slide 23, substantive law, procedural law, public law, private law. I'll bet that some of those terms could wind up on part A. All right, so just a heads up there. First thing is substantive law. Substantive law are the rights and duties of each person in society, or in other words, the law that we have to obey. Homicide, manslaughter, infanticide, no breaching of contracts, no committing torts. These are laws. These are the substantive laws. Okay. But what happens if you and I have a contract and you breach the contract? What do I do? Well, I'm going to sue you. So how do I do that? Okay, you're sued. No. I have to go to the appropriate court registry. I have to fill out either a notice of claim if it's small claims court, or a notice of civil claim if it's a BC Supreme Court case, and I have to pay a fee, get it stamped by the registry, and I have to serve it on you, the defendant, some way. In small claims court, service is relatively simple. You can do it by mail or other means. In BC Supreme Court, you have to actually physically serve that on the person. Okay, so and then that person has 14 days in which to make up a decision. let it go by default, settle a matter, or defend against it. How do you defend against it? I'm defending. No, you have to go to the court. You have to file a statement of defense. And then there's a whole series of procedures that you have to go through to get to the trial. These are called procedural law. So there's substantive law, the laws you have to obey, and then there's procedural law, the laws you use if for some reason you are wronged by someone. Okay. Then another two terms, public law and private law. Well, Regina versus Dudley and Stevens is public law. How do we know? Regina, the Queen on one side, the government, versus Dudley and Stevens, individuals on the other. Or it could be the Minister of National Revenue versus ABC Manufacturing Corporation. The Crown on one side and a corporation on the other. Or a constitutional challenge. The government and right, or the Queen and right of the government of British Columbia versus the Queen and right of the federal government of Canada. So it's a constitutional battle. This is all public law. The conduct of governments, government against government, and with the relationships between governments on one side and private persons on the other. Private law is the rules governing the relationship between private persons or groups of persons. Okay. Now, persons doesn't say anything in there about corporations. So what about that? Well, a corporation at law is considered to have all the powers and capacities of a natural person. Okay. All right. There's a diagram on the next slide which tries to further show this delineation. And what this will do is give you some examples, but it'll also show you that this isn't a perfect division, right? So under public law, you can see that there's criminal law, there's constitutional law, there's marketing and advertising. Wait, marketing and advertising, isn't that like business? Wouldn't it be business against business? Yes, except if somebody falsely and misleadingly advertises their products, you go to the government to lay a complaint. So you go to, if it's federally, it's the Competition Bureau. If it's provincially, it's under the Business Practices and Consumer Protection Act. And there's a designated person in our government that you can make a complaint to. So, okay, marketing and advertising should be public, except for the situation where somebody falsely and misleadingly advertises and I suffer a loss and I complain to the government. Well, the government goes after them and they fine them. Do I get the fine? No, I don't. So in the Competition Act, which is the federal statute, for example, you complain to the Competition Bureau, they can fine the person. Okay, but then there's also a provision which says if you suffer a loss, you can also make a claim. So what that means is that marketing and advertising is under public law, with the exception that there's one little bit that falls under private law. So it's not a perfect division. Taxation, obviously public law, Minister of National Revenue or the CRA on one side and Smith on the other. And then there's below, a little farther down beside my scales of justice, the international law. Oh, wait, international law's on the other side too. That's bizarre. Well, obviously there's international law like NAFTA, which is now the USMCA or something or other, because Trump had to rename it to make it his, although very little was changed in it. Anyway, it's on one side because there's countervailing duties and there's those tribunals in which, Canada fights against the United States or United States fights against Mexico over these countervailing duties. Obviously, government against government. There's also a provision under the Act which has not been used but is there, which allows for me, if I'm selling milk to Mexico and I don't get paid, I'm not going to get the government of Canada to do anything about that. It's just a breach of contract. So what you do is you have a situation where there can be arbitration with me arbitrating or using a government facility to go after the party on the other side. So it's on both sides. international law, there's also situations where one business in one jurisdiction sues another business in another jurisdiction. It's international because it's cross-border, but it's very specifically just one business against another, which fits on the private side. Administrative law, what you have is a situation where we have these crown agencies. We have the Employment Standards Branch, federally and provincially, Human Rights Branch, the Workers' Compensation, Employment Standards. Did I say that already? We have these government bodies which resolve disputes. Okay, but it's always the government on one side and somebody that has contravened the Human Rights Code on the other. That's definitely public law. However, take the Labor Relations Board, which may resolve disputes between the government and the public civil service, and it would be on the public law side because it's the government and the government union. But then the Labor Relations Code in British Columbia also resolves disputes between a business and their labor union. Okay, the government's Labor Relations Board resolves those disputes and also a dispute between the provincial government and the provincial civil servants. So administrative law is on both sides. So again, the division isn't perfect. All right, well, let's look down the right-hand side. Private law, contracts. Obviously, if I have a contract to provide you product and you're going to pay me, private law, me on one side, you on the other. But what happens if I'm selling pencils to the government and they don't pay me for them? Well, I'm going to sue the government. It's me on one side and the government on the other, but it's still private law. Okay. Tort law, it's the government could be negligent, okay, by, I don't know, not cleaning the ditch in front of your place so that it floods, ruins stuff in your basement. So it's you on one side and the government on the other. But it's a tort, okay, and it falls under private law because the remedies would be private. Family law, obviously, we have the Divorce Act federally and we have the Family Relations Code in BC. But even if the Divorce Act doesn't say the government on one side will go after your husband for cheating on you. No, you have to go after your husband for cheating on you. And that is private law. There's a federal statute that applies, but we have private law. So that's family law, company law, obviously private law. Wills and estates, each individual province has their Wills Act or their, as we have the Wills, Estates and Succession Act, and that's very much private. Intellectual property, wait a minute. You file patents, copyrights, trademarks, and industrial designs with the federal government. Why isn't it on the public law side? Because if someone infringes your trademark, you sue them for trademark infringement in the court system, but it's you against the other business that infringed, and so it's on the private law side. And yet, even here, there's a little bit that falls under public law. For example, under the Copyright Act, if you have some specific software and you sell it to businesses and you say you can use it but you cannot copy it and give it to other people, and then you find out other people have your copyrighted material, what do? Well, how do you go on to their business premises, find out that they're using your software? There's no way you can. You don't have the right to. That would be trespassing. And so there is a provision under the Copyright Act, for example, which allows for you to make a charge against that person under a provision in the criminal code, and then the government goes in and searches, okay? And they can actually fine people for unauthorized use of copyrighted material. And then you have the proof that you need to sue them civilly. So that's a situation where intellectual property law clearly falls under private law, with the exception of one little bit that falls under public law. Okay, so this would make a very good Part B exam question, because I could say, explain public law and private law and in doing so, provide examples and explain if that example is purely public law or purely private law, or whether they fall in both, something like that. All right? Changing gears again, it's important for us to even understand Canadian law to really have an idea of the legal systems of the world. And so we're going to look at three legal systems and take a hard look at them and see how they may apply to Canada. Now, there are numerous legal systems in the world. There's the common law system, which we use in Canada, with the exception of Quebec. There's the civil law, which is continental Europe, most of South America, and lots of other countries. That Quebec has. United States has Louisiana. The United Kingdom is the birthplace of the common law. So obviously civil law doesn't apply. Yes, it does. It applies in Scotland. So we have the common law system, we have the civil law system, and then we have the Islamic law system. There are other systems. There's the Judean system, which is very specific to Israel. And then there are lots of African countries that really have something more resembling tribal law. We are only going to look at three. We're going to look at common law, civil law, and Islamic law. Now, I'm just going to take a short break, and then we'll get into that material. Okay, back after the break. Had that break so that I could go and have a cup of coffee. I hope you had one too. Now, probably a good point to, again, talk about how to use the textbook. And I see this is a good point because obviously by now you're supposed to have read the pages on the business scenario, and then you get into chapter 1, and on page 6, we start talking about the three legal systems in the world. And I sort of have it in reverse order. It talks about the Islamic system, then it talks about the civil law system. And it starts off talking about the 12 tables which apply to the citizens of Rome. And the question that should come into your mind is, do I have to know about the 12 tables or what the 12 tables are? Because I recommend that you read the textbook. No, you don't. Because I'm not going to talk about the 12 tables in my lecture. What I do on the exams is I examine you on only the material I cover in class. Okay. I may add some material in class that is not in the textbook because, for example, we don't talk about contracts in the pandemic in the textbook, but I'm going to talk about that in class. So that could be on the exam and not in the textbook. What the textbook does do is fleshes out in much more detail the concepts that I go over in class, because we don't have the time in the lecture to actually just read through the textbook, and if that's what we were doing, you could do it at home without me. Okay, so main legal systems of the world. On slide 25, we have the civil law system, a comprehensive legislative code of laws derived from Roman law that developed on continental Europe and was greatly influenced by the Code Napoleon. So then I have a picture of the Corpus Juris Civilis Romani, and gosh, here's some Latin. Corpus, body, right? Juris, law. Civilis, civil law of Rome. Wow, now we know Latin. Okay, so back in Roman times, Rome had a very sophisticated legal system. It had laws, it had courts, it had senators who acted as legal counsel for people that had to go to court. There was a saying back in those days that a Roman citizen could go anywhere in the Roman Empire and be safe. Not exactly true, but what it meant was that the Roman law would protect Roman citizens to the greatest extent possible. not slaves, not other people, but the Romans. Okay, so the Roman Empire got to its height, and then the barbarians became stronger. And they began to defeat the Roman army, particularly in Northern Europe. And, I mean, you can only fight so many wars for so long before you start running out of really good young men for your army. And so the Roman army was less and less able to stop the march of barbarians. And they were going to march on Rome and plunder Rome. The Pope and the Roman Catholic religion was very strong in the city of Rome and very wealthy. And so rather than let Rome be plundered, the Pope sent an emissary out to talk to the barbarians and said, look, what do you want? And they said, we want wealth. And he said, okay, how about if I pay you and you go away? And they said, oh, okay, that's a pretty good idea. It's a lot more complicated than that, but he paid the barbarians and they went away. Years later, they've used up the money. They start coming on Rome again. The Pope isn't going to pay them this time. He moves to Constantinople, I believe. The emperor at that time was Justinian. He did not get his name because he was just. It was just a name. Our concept of justice comes from his name. But his advisors came to Emperor Justinian and they said, look, the Roman army is not strong enough to stop the barbarians. Rome is going to be plundered. Everything of wealth should be hidden because they will plunder and take the gold and silver and tapestries and statues. So you must hide the wealth of Rome. Justinian had a different idea of what had everlasting value. And he thought all those gold and silver and everything are transient wealth, whereas the laws of Rome should be what is safe. So he painstakingly wrote out the Corpus Juris Civilis Romani, all the laws of Rome. First time that that's not quite correct. Hammurabi in the Middle East had codified their laws. So Justinian did something the same. He wrote out all the laws of Rome. And he took those scrolls and he hid them away in monasteries in Italy. The barbarians plunder Rome. They steal the gold, the silver, the tapestry, burn the tapestries. They smash the statues, grab all the wealth they can, and they leave. However, the scrolls survived, and the monks in the monasteries began to study the scrolls and copied them and sent them to other monasteries in Italy and all across continental Europe. Okay, Italy didn't even exist at the time as a separate nation, as a matter of fact. So they just sent them to monasteries. The monasteries also sent them to universities for study. And universities in those days are not like our universities. You come here, you get a business degree, you go out, use the degree to get a job, make money. Back in those days, universities, you went there for a whole lifetime. And it was your job to expand knowledge. All right? So they were studying them. At the time, the states in Europe began to be formed. They needed public law. There's the Justinian Code. So they all began to use that in the setups of their states. Then there was this fellow Napoleon. I don't know whether I've got it on a separate screen or not. No, I don't. I usually have a picture of Napoleon and the Napoleonic Code. Napoleon thought of himself as a bit of a legal jurist, and his best friend was a legal jurist. So the two of them got together and they developed the Napoleonic Code as the laws of France. And whenever he conquered a company, he would instill the code. This worked really well. Just as in Roman times, Rome was very smart. When they conquered a country or a group of people, they did two things. They instilled the laws of Rome, which brought order, which people appreciated. They improved the economy immediately, which people appreciated. And then they looked at the defeated army, all the survivors, and they thought there are a lot of unemployed warriors that will just begin to plunder and rob if we don't do something about it. So they invited them to become part of the Roman army. So things improved really dramatically. Well, Napoleon conquered a country. He would go in and he would instill his laws, which brought order. All right. Well, Napoleon meets his Waterloo and is defeated and exiled. And all those other places that he had conquered were really happy to be rid of Napoleon. But Germany, for example, said, well, we're glad to be rid of Napoleon, but his Napoleonic code worked really well. And so they decided to keep the code, as did Spain, as did Portugal, as Italy. All those countries kept the codes. Well, they couldn't call the Germanic code the Napoleonic code, so they changed it, obviously, to meet their own needs. And so we have all these code jurisdictions. First thing we have to remember is the codes are not identical. Okay, in France, it was the French Revolution, and they had this attitude of life, liberty, and so their code was more of a living thing. In Germany, it was very, very precise. We are going to have these laws, which are going to govern our society, and that is it. Okay, so they're different in degree of flexibility, but they all relate to one document which lists all the laws. You have a problem, you go to the code, you find the section, you begin your legal action because you have contravened, or somebody has contravened that section of the code. Which means that there's a lot more consistency and predictability from one time to the other. No reliance on precedent, okay? So some differences. No precedent. So you don't come in and argue your case under Article 5 of the Code because last week in the courthouse down the hill we have a decision which is similar. No, you don't refer to that, all right? The judge makes the decision on the wording of the sections. So much so, pardon me, that in civil law jurisdictions, judges go to school to learn to be judges. They don't go to become lawyers and then get to be judges. They go to school and they learn to be judges because they just have to interpret the words. And then you have people that go through law school. Not like our jurisdiction where you have to almost 99.9% of the time have to be a lawyer before you become a judge. In a criminal matter, you are guilty until presumed innocent, which is the exact opposite from common law, where you are innocent until proven guilty. Pardon me, I'm going to have to take a cough drop. My apologies. You have to prove you're innocent. The only person that believes you're innocent is your lawyer. The other lawyers, the jury, the clerks, the public, everybody believes you're guilty except you. It is an inquisitorial system, comes strictly from the Spanish Inquisition, where the judges got involved in the trial and tried to prove that you were guilty. Okay, they can ask questions, they can call witnesses, very different than our system. Let's see, no reliance on precedent. Those are the key differences. So continental Europe became civil law jurisdictions. France, Germany, Italy, Spain, Portugal all had their empires. Wherever they conquered a nation and made it part of their empire, they instilled their code. So Spain, for example, conquered the Mexican people. And they instilled the Spanish code in Mexico. Mexico has its revolution, kicks Spain out. Good riddance to Spain, but hey, that code works really well. So the first Mexican civil code, basically they stroked out Spanish on it, Spanish civil code, and they put in Mexican civil code. It has developed differently over time. Since then, but the codes were very much reflective of the conquering country. So Mexico, Latin America, most of South America, Vietnam, the French were in there. They have a code. Northern Africa, codes. Japan, a code. More area of the world is covered by the civil code than the other jurisdictions. Islamic law covers more people, and we'll get to talk about why common law is even important at all. So that's the civil law jurisdiction. Now, what happens if you have a problem where there's no article in the civil code which applies to your situation? In Canada, you actually have to argue with the judge to say that, hey, you should create a new cause of action. However, the civil law jurisdictions take a different approach. They say that what you do is you look in the civil code and you find a particular article, and then you extrapolate. You say, okay, that article is the closest article we have. Now I can use that to get into court. I had an opportunity to talk to a Supreme Court of Mexico judge from the state of Jalisco, and he said that no one in a civil law jurisdiction is prevented from bringing an action in a civil law court if they cannot find an article in the civil code which applies. So our situation is a little different. If there's no cause of action, you have no access to the court system. You might get a clever lawyer who then tries to frame your action close to something else and convince a judge that he should create a new cause of action. It's a much more difficult system. Okay, so that's the civil law system. And now we're going to look at the Islamic law system, or the Muslim law system. And it's derived from the Sharia, which has 4 elements to it. The Quran. The Quran is similar in the Islamic jurisdiction to the Bible and Christianity, although there's obvious differences. But the Quran is very similar to the First Testament. We have Moses, and we have the 10 Commandments. We have Moses talking to the burning bush. All those things are similar in the Quran as in the Bible. And then the question becomes, well, if they're so similar, what are we fighting about? Or we're fighting about oil, the price of oil, and things like that. It's not really a religious battle. But I'll come back to that in a minute. So that's the first thing, the Quran. Now, we hear people say, oh, well, the Quran says if you kill an infidel, then you shall sit in the right hand of Allah and have 72 virgins and milk and honey. It doesn't say that anywhere in the Quran. That comes from the writings of the Islamic scholars, deriving rules by analogy from the principles in the Quran and the Sunnah. The Sunnah being the preachings of the Prophet Muhammad, who apparently Allah visited in his dreams, his day and night dreams, and gave him guidance. So you have the decisions or the writings of the Islamic scholars, and here's where things go off the rail. Because in their society, I believe the education system in Canada is faltering. I believe the education system in the United States has got to be pathetic if 38% of the people in the United States can't understand when their president's telling a lie. But anyway, the education system in the Middle East is getting better, but it's not very good. In the sense that back in the olden days, very few people knew how to read and write. So consequently, the only way they could know what was in the Quran was if someone read it to them and interpreted it for them. Islamic scholars would do that, and then of course there were always some who would then take the word and twist it around and give it their own interpretation, and then incite people to strap bombs on themselves and run into buildings. For example, nowhere in the Quran does it say, "O ye, if you kill an infidel, you'll sit on the right hand of Allah." What it says in the Quran is, "O ye, if you are attacked by an infidel, then kill the infidel." Pardon me, folks, if we're attacked, we kill the infidels too, which is the other side, right? So there's nothing unusually terrible about that. But the Islamic scholars put it in terms of they are attacking our religion, and they, and that sort of thing. And then you have the development of these, groups like the Taliban and the ISIS and things like that. But we don't have that in Christianity. Oh no, we don't have that at all. Christianity has more of these weird sects than does Islamic law. We have the white supremacists and all those people. So there's good and bad on both sides, and the only thing that will save the world is if it's mostly good on one side. All right, so that's the writings of the Islamic scholar. And then we get to this fourth thing, which is called the census of the legal community, consensus of the legal community. In the Middle East, most of those countries were French jurisdictions, or colonies, and so France instilled the civil code. When they were forced out of the countries, there were a lot of good things about the code that those jurisdictions liked, and so they kept them through the consensus of the legal community. Okay, so we have the Quran, the Sunnah, the decisions of the and sayings of the Prophet Muhammad, and the writings of the Islamic scholars, and the consensus of the legal community. What you have is in the Quran more actual law than is in the civil code or in the Bible. We have the Ten Commandments in both, okay. But in the Quran we have some procedural law. And I have on the screen, number 27, a paragraph from the Quran. It's from the chapter called The Glorious Quran, Sunnah number 2, the cow. O ye who believe, when you contract a debt for a fixed term, write it down, and let a scribe write it down between you with fairness. That's one interpretation. I know a bit about this because I taught, I still do teach international trade and law, and that's very much about the various jurisdictions. And I apologized to them in one class, and I said, I don't know enough about Islamic law, so I'm just going to give you what's in the textbook. One of my students said, well, I'll give you a copy of the Quran, and this is considered to be the best and most honest translation. And I read it, and she said I could keep it, and I still have it, and I generally circulate it, although unfortunately we're not going to be able to do that this time. Anyway, I read it, and that's how I knew, what was in there and what wasn't. I found it to be a very difficult read in English. The reason is it is more melodious than the Bible and other books. Melodious, why? Because people could not read. And so generally it was read to them, and they would memorize it, and it almost has to be sung. Okay, and so there's a lot of repetition, just like a song has a chorus which repeats. So when I was reading it, I saw this one section, and I read it, and it actually reads slightly different than slide 27. Slide 27 says, "And let the scribe write it down between you with fairness." In the best translation, it says, "in terms of equity," or "in terms of justice," and I like that. And then it says, "and call to witness from among your men 2 witnesses." Well, we have a witness for one party and a witness for the other, so our contracts have 2 witnesses as well. Now, back to my international trade law class, Another one of my students said they had a friend in Victoria who was an Islamic scholar, and he would come over and talk to us. And I said, well, the problem with that is we have no budget to do that sort of thing. And this student said, no, he will go anywhere, anytime, to talk to people about the Quran and Islamic law, because he does not want people to learn what's in the Quran from someone like George W. Bush. Okay? So I said, great. And he was coming over, and so I was reading the Quran, trying to get through it. I had about 2 pages left when this fellow burst into my office and said, hi, I'm so-and-so, and I'm from Victoria, and I'm here to talk to your class. And I said, well, I'm Peter Holden. He looked at me and he said, are you a Muslim? And I had the Quran in my hand, and I said, yes. And he said, oh, well, that's the right answer. But why would you say that? And in the Quran, it says, O ye who believe in the one God. And it becomes very apparent that that one God is the Christian God, the Islamic God. And, they're one and the same being. Now, I wasn't being, I guess, totally honest with him, because I understood that the answer I should give was that, yes, I am a Muslim. It's not that I don't believe in whether there's a God or not. It's just that I don't want to waste my time on earth trying to figure out whether there is or isn't. And I'm up in my soapbox right now. But my attitude is, one person is never going to be able to convince another person that there is a God, and that other person is never going to be able to convince the first person that there isn't a God. The only way to find out is die. And so I'm not going to spend a great deal of time worrying about whether there is or isn't a God. What I'm going to do is try to be the best person I possibly can, and if I die and there is a heaven, I should get into it. If I wasn't good enough, then I go to hell. All right? But at least I'm going to live my life the best as possible. On the other side of the coin, if there isn't a God and there's just oblivion, then I didn't waste a lot of time worrying about it. So my attitude is, just don't worry about it. For other people, it's different, and that's why we have religious freedom guaranteed in our Constitution. Okay, so he came over, and this Islamic scholar, and he went in to talk to our class. Well, by the way, he used to be a colonel in the Egyptian army, and whew, he was big. If their army was like that, wow. Scary guys. Anyway, a very nice man. He comes in, he's talking to the class, and then we talked about this section, and we got to the next line. It says, call to your witness from among your men 2 witnesses, 2 men, right? But if there are not 2 men, then 1 man and 2 women will do. So it took 2 women to equal 1 man. That's where that class went off the rails. The females in the class began arguing with him, why does it take 2 women to equal 1 man? And his answer to that was, there's Allah sitting there. He says, I have created men and women. Someone has to be in charge. Man, woman, men. Okay, so men are in charge. Well, you could just understand where that went in class. They were still arguing when the class was over, and I got up and left. Anyway, and then the witness can be called to court, and he must not refuse to come. This is all procedural law. The next paragraph said, what if you're traveling and you want to lend someone money? Well, the other person can say, okay, I want security that you're going to pay me back. Sounds like the Personal Property Security Act in the province of British Columbia. If you cannot take security by some way, an agreement, then you take it physically. Okay, it's called a possessory lien, which we have in our jurisdiction. So you can see how the Islamic law governs. The Middle East, Lots of, Pakistan, lots of countries follow Islamic law. More people are covered by that law than other jurisdictions. It has no direct applicability in Canada, whereas Canada, for example, has common law and civil law. We do not have Islamic law play a role here. Okay. I'll deal. I was going to deal with something, but I'll deal with that after I talk about common law. So now we move on to the common law system, and it's a system of law characterized by case law, which is law developed by judges through decisions of courts and similar tribunals. Precedent is a deciding factor in our law. This comes from the Magna Carta, which in Article 18 says, inquests of novel decinen, which means new court cases, of mort d'ancestor, which means estate matters, and of Hadrian presentment. Hadrian is land, last or final, which means what happens after you die, shall be not be held elsewhere than in their own county courts, which means you don't go to see the king or the king's representative, which was the chancellor. You go directly to a court where you live. Or if we not be out of the realm, that's the barons. Our chief justiciar, I'm not very good at pronunciation, but our chief judge will send out 2 judges through every county 4 times a year, who shall alone with 4 knights chosen by the county hold these assizes, these courts, in the county courts on a day and in a place of the meeting of the court. So suddenly, instead of hand-to-hand combat or deciding things by trial by fire and things like that, we actually have courts making the decision. So let me just go back. So we now have these, well, what happened before? Let's look at it that way. And why wasn't England under the under the civil law jurisdiction? After all, Rome conquered most of England. The story behind that is that as the Roman Empire expanded, they were literally running out of Roman soldiers. And so when they conquered an area and there were all these unemployed warriors, they would get them into the Roman army. You're unemployed, you need money to support your family, why don't you join the Roman army? Better uniforms, nice organization, good food, chance to travel. Sounds like a poster for the United States Marine Corps. But anyway, they would do that. And so by the time the Roman army conquered the United Kingdom, conquered what would become England, and only the southern half, there was only one Roman in that whole army, and that was the Roman that became the governor. Okay, the rest of them were made up of barbarians who joined the Roman army. So the governor gets into Rome, and they had pushed the argumentative Brits and Scots north, and the governor said, "Wow, I'm going to have a hard time holding on to this province." So, because the army is made up of rebels that look like the rebels were fighting, and I'm so far from Rome. And so he decided to build the Hadrian's Wall, which is basically the border between England and Scotland, to keep the barbarians out. And he decided to let the people keep their own law system, okay, rather than trying to instill Roman law. So the law system at that time was trial by fire or trial by ordeal or hand-to-hand combat. So let's say you are charged with an offense and out comes the sheriff, and you're going to be put on trial. What they would do is they would say, okay, you're the accused, and they would put a red-hot poker in your hands, and you would have to walk 30 paces holding on to this poker without dropping it. If I drop it, I'm guilty. If I make it 30 paces and then drop it, if I have blisters, I'm guilty. Okay, so trial by fire was almost a guarantee of being found guilty. Trial by ordeal, one of the ordeals, particularly used with witches, was you would be tied up and thrown in the water. And if you sank, you were innocent. If you floated, you were guilty. I often wondered how long you had to sink before you were actually found innocent. Anyway, very, very brutal. Well, that's the government on one side and the individual on the other. Public law. What about private law? What happens if you steal my pigs and I want to confront you? Well, we go to court, right? I sue you. No, there are no courts at this time. And so what I would do is I would challenge you to hand-to-hand combat. Well, what I usually do in a class when I'm doing this is I pick a student who is young and big and burly, and I say, okay, stand up. And let's say it's Bob. And Bob is suddenly huge. And I think, oh, no, I'd rather challenge Frank, who's short and small. Okay? But let's say Bob is the person that I think stole my pigs. I would have to challenge him to hand combat on the field tomorrow at sunrise. Well, tomorrow at sunrise, I go into the shed and I look around, and here's the hoe, and here's the plow, and here's my shovel, and oh, here's the sword from when I used to be in the army. And I pull it out and I go, it's heavier than it used to be because I'm a little older, right? And I look over and there's Bob. He used to be in the army too. And I think, he's bigger, younger, stronger. I'm dead. Okay, so what do? Well, I look around. There's Abdul. Abdul is big and strong and burlier than Bob. And Abdul used to be a knight. Bob was just one of the army. One of the grunts. A knight. So I go over to Abdul and I say, Abdul, if I give you a few pieces of silver, will you fight Bob for me? Sure. In England, in those days, the king had the knights. Remember King Arthur and the Knights of the Round Table? Well, the king had knights, these trained soldiers to fight wars, plus all the grunts that, became the cannon fodder. When there was no wars, these guys were unemployed. They would literally starve. Instead, they would ride around England, being champions for the people. I used to watch a show called Ivanhoe. This guy was in this silver armor, and Ivanhoe, and I thought, whoa, I'd like to fight for justice. He was a hired gun, okay? And he didn't necessarily fight for justice. He fought for one side in a commercial argument. So a bit disappointing now to look back at it. But anyway, I hire Abdul, and Bob looks over and he goes, oh, Abdul, oh, I know him. He's good. I can't beat him. So what's Bob do? He looks around and he sees Francis, a knight. He's about the same size and looks about as strong as Abdul. So he says, Francis, if I give you some silver, will you fight Abdul for me? Francis, unemployed, needs money. He says, sure. So the ludicrous thing is, at sunrise, there's Bob and I standing on the side of the field watching Francis and Abdul fight to the death over our contractual dispute. So let's say they battle and battle and battle, and Abdul goes, and he gets right across there, a death blow. to Francis, right? But Francis, as he's going down, goes and gets Abdul on the side. Well, last man standing. Abdul wins. I'm right. Bob, you pay me for the pigs. Bob pays me. Okay? Francis is dead. Abdul goes to the hospital. There are no hospitals. They would take him to a local monk who would do some incantations and put some herbs and moss on the wound, and then take a hot poker and cauterize the wound. And Francis dies a couple of weeks later of gangrene or infection or something like that. So what you've got is a situation where I have proven my case by having Abdul win the battle for me, and then the king has lost 2 knights. So the king finally gets around to deciding when he let's have a war. Gather my knights, and 3 or 4 guys show up, and he goes, "Where's my army?" Well, they've all been riding around England, getting involved in these contractual and land disputes in hand-to-hand combat. So you can see that the public law and the private law of England was not serving the needs of the people particularly well. So let's change the scenario. Now we have these judges that have been appointed by the barons, and they come out to settle disputes. Now I have a dispute with Bob, but hey, I've got the upper hand because I can out-talk Bob. So what's Bob do? Well, Bob goes and he hires someone to speak on his behalf. And I go, oh, wow. I could have out-talked Bob, but I can't out-talk this other person. So what do? I go out and I hire somebody to talk on my behalf, okay, before the judges, and bingo, the legal profession is created. Who are these people? Well, you needed someone that was well-educated and well-spoken, and so you would think that the religious leaders would be the obvious choices because they are well-educated, they read, they write, they're well-spoken. But there was a separation of church and state, and so they would not do it. The next most important group of people who are well-educated, well-spoken, used to negotiating and arguing, were wine merchants. These people would go from England to France or England to Germany, and they would buy wine. Well, they had to know languages, they had to know how to negotiate, they had to know monetary considerations, and so they made really good advocates. These people would argue and then eventually say, gee, I could take a bag of gold and try to get from England to France and buy wine without being robbed. And then I have to get the wine from France to England without being robbed. Or, hey, I can just have people pay me to talk. I mean, what kind of great gig is that? And so these people eventually became full-time advocates on behalf of people, and they eventually became our lawyers. When they created the court system, the barons didn't say, okay, we need court systems, so we need judges, so we need lawyers, so we need law schools, we need law professors, we need exams, we need bar exams. No, they just started off with the judges. So these people eventually became advocates. And that makes one big distinction between this common law system and the civil law system. The civil law system is inquisitorial, where the judges very much get involved in the court cases. In the common law system, it was hand-to-hand combat, with Bob and I observing from the side. So we changed that now, and we have the judge observing what's going on, sitting in his, at his desk, and we have 2 people taking the place of our knights in shining armor, doing verbal battle. And so it became an adversarial system, just like battling with swords, as opposed to an inquisitorial system. So judges in common law systems are considered to be impartial, unbiased observers of fact. Okay, who's the better fighter? Who has the better argument? Now, what happened is they would make decisions, and some of these advocates would think, I've won. Okay, that decision might help me. And so they would ask the judges to write their decisions down. The judge would keep a copy, the lawyer would have a copy, and then he would go to court on a similar situation. And so he would make his arguments, and then he would say, and I have here a decision of your brother judge, so-and-so, granted on such and such date on a matter similar to this one, and you may find it helpful in coming to the decision in this case. Bingo, precedent is born. The precedent system developed, well, I should just back up and finish. So we have the civil law system, and now we have the common law system. And the common law was born in England, and England had its worldwide empire, and everywhere that it went, it instilled common law within certain degrees. In England, when it became the United Kingdom and Scotland became part of the United Kingdom, Scotland had civil law. Civil law, but only for private law matters. Okay, the United Kingdom has public law, which is common law completely. In Scotland, civil law, just for private law matters. Okay, so come to Canada. We have Canada being formed, and then we have the United States breaking away. Well, then there's the United States down here, and there's Canada up there. And when the United States started doing their manifest destiny idea that, that all of North America should be part of the United States, the United Kingdom thought, oh, okay, our colonies in Canada are at risk. And so what they had to do was placate the French Canadians to stop them from siding with the Americans. So they allowed the French Canadians to keep their religion, keep their language, and keep their legal system. Okay, so civil law in Quebec, common law in Ontario and the Atlantic provinces. So that's here. In the United States, when the United States was formed, there were only 13 colonies, and it was all common law, similar to England. They kept the legal system, but got rid of the king, and now they have another king. And they're going to have to get rid of him too, I think. I'm talking about Trump, by the way, and I'm up on my soapbox when I say that. But they got rid of the king, but they kept the legal system because it worked. Okay, and then as the United States began to grow and grow and grow, they purchased Louisiana from the French. Well, Louisiana had a civil code. And so when Louisiana became a state of the Union, they kept their own legal system, civil law. Okay, when California became part of England, California was a huge Spanish population then, and now it's a huge Spanish population again. Their legal system, although it is common law system, is highly influenced by the civil law aspects of their development. This is so much so that by the time if you said, what country in the world follows common law only, the knee-jerk reaction is the United Kingdom, the birthplace of common law. No, because Scotland follows civil law. Oh, well, Canada. No, because Quebec follows civil law. Oh, well, the United States. No, because Louisiana follows civil law. So you have to go to Australia or New Zealand to find a common law jurisdiction which is purely common law. Now, on the exam in the past, I've put a Part B exam question on the three legal systems of the world, and I say, explain them, and then give an example of a jurisdiction which follows purely that type of law. Well, obviously, as far as civil law is concerned, you would have to say that, well, you could say it was France, it was Germany, it was Japan, it's Vietnam, it's Mexico, it's Venezuela, all these countries, right? But if you said, okay, now what about common law? You cannot say, oh, Canada with the exclusion of Quebec, because no, that's not exclusive, all right? And you cannot say England because it's a country, because it isn't a country. The United Kingdom is a country, and Scotland is part of that. So you'd have to say Australia or New Zealand. And then you go to Islamic law and you say, okay, what Islamic country in the world follows Islamic law purely? Oh, Iran, Iraq. No. They were highly influenced by the civil law. Oh, well, Egypt. No, Egypt is schizophrenic. Okay. France had them as a colony, so there's influences from the civil code. Then the French were kicked out by the English, and so they brought in their common law system. And then the Egyptians kicked out the English, and so now they have aspects of their system that follow common law, civil law, and Islamic law, with obviously Islamic law being the serious one. So what country in the world follows only Islamic law? Saudi Arabia. So curiously, United States, keen supporter in the Middle East, their ally in the Middle East is the one country that follows Islamic law purely. Okay, back to the common law. We're talking about precedent. We know it comes from the court systems, from the Magna Carta. Why then do we have this system of precedents in the United Kingdom rather than civil law? And there are 5 historical incidences which allowed for the development of the common law or the maintenance of the common law. And I like throwing in some history in all of this. There's Hadrian's Wall, a separation of the civil law barbarians from what became England, and it preserved their own laws, which then developed into the common law system. Then there was the Magna Carta, which is the birth of the true common law legal system of precedent. That was in 1215. And then there's the Spanish Armada. Now, how could a naval battle between Spain and England actually help the maintenance of the common law system in England? Well, Queen Elizabeth I was the ruler of England at the time, and there was a series of political machinations which led to the Spaniards deciding that they were going to conquer England. And the Spanish Armada was a smaller fleet than the English fleet, but much larger, stronger vessels, well armored, lots of cannon. And the Spanish Armada sails north, and they're going to defeat the English Navy, and that would mean the collapse of England. Queen Elizabeth went to a pirate, Drake, Francis Drake, and she said to Francis Drake, you have a substantial armada. What I would like you to do is join with the English Navy and fight the Spaniards. Well, the English Navy and the pirates' ships were all much smaller, less well armored, fewer cannon, but there were more of them, okay. And so Drake sails out to challenge the Spaniards. New technology often turns the tide in a war. You only have to look at the defeat of the Japanese in the Second World War because of the development of the atomic bomb, which the United States had and they didn't. You look at the development of better air power by the Americans and by the British, which helped defeat the Germans and Japanese. And so those with the best technology generally win wars. And it was the same in the Spanish Armada. Drake knew something about science, Okay, if you ignore science, you do so to your peril. I'm up in my soapbox right now, but President Trump is ignoring science, and it will be, I think, to his peril. And a lot of people are going to die because of it. Anyway, Drake knew that if you fired a cannonball and it hit the water, because of the surface tension of the water, the cannonball would skip and go farther. It would still be hot and explosive, but it would go a longer distance. And so as the two fleets were approaching each other, Drake began to shoot. Boop. And the cannonballs were hitting the Spanish fleet and causing fires and huge damage and everything. And the Spaniards are going to say, wait, what's going on? We're not within range. How could they do it? What magic is this? And Drake had pretty much decimated the Spanish Armada before the Spanish Armada even got close within range of the English fleet. This allowed England to remain common law, but it was also the deciding factor that allowed Scotland to become civil law. Drake was not satisfied with defeating the Spanish Armada. He wanted to sink every last ship. So after the battle, he sailed behind them to cut off their return to Spain so that he could sink them all. The Spaniards, in desperation, sailed up through the North Sea with the idea that they would sail up around England and get back to Spain. The Spanish Armada got caught in two huge storms, and all the ships were lost. Many of the sailors, but predominantly the officers, got to shore of Scotland, and the Scots weren't particularly fond of England, so they hid them. Well, it's not like you're a Spanish sea captain and you can just say, okay, thanks for hiding me for a while, now I'll just get on a plane and I'll fly back to Madrid. They had no way to get back to Madrid, so they stayed and became part of the population of Scotland rather. And they followed the civil code. And so the civil code began to develop in Scotland, and that's why they got to keep their law. But the defeat of the Spanish Armada allowed the maintenance of the common law system. The Battle of Trafalgar, this is Napoleon. He's conquered most of continental Europe. He's got his eyesights on England. He lost a huge fleet to the British in Alexandria in Egypt. But he had built up the fleet again, and he was going to sail and defeat the British Navy, and then the Spanish army the French army could conquer England. One of the most famous and most successful of all time naval admirals, Admiral Nelson, was in charge of the English fleet, and he was such a strategist that he managed to defeat and destroy Napoleon's navy, and that was the eventual decline of Napoleon's power. Nelson, by that time, I think had lost an arm. He had an eye patch. He even had a damaged leg. But he commanded the fleet and was killed in the process. But because of his efforts, England remained a common law jurisdiction. The last serious threat to English common law system came in the Second World War, when Germany, who is no longer a civil law jurisdiction per se, but a dictatorship, was going to conquer England and take over the country, and that would have been the end of the common law system. The Battle of Britain, Germany was going to use its huge Luftwaffe Air Force to decimate England to prepare for the landing of the German army. But the Battle of Britain, in which many British pilots were lost, a lot of Canadian pilots were lost, some American pilots who came over and joined the British were lost, Polish pilots were lost. England had the Spitfire, which was a better plane than the Luftwaffe. Can't remember the name of the German plane. The Messerschmitt. And the Battle of Britain, the British took control of the sky, okay, and that allowed them to prevent Germany from invading England. So those 5 events, historical events, either allowed for the development of or prevented the decimation of the common law system. Now that would make a really nice Part B exam question because there's 5 elements to it. So I could say, list and briefly explain how these 5 elements or historical events allowed England to develop and maintain a common law system. All right, so that brings us to the concept of precedent itself. And and I will just finish this. Let's see what the next topic is. Yes, we'll stop when we get to the Constitution, and we'll deal with it later. Okay, the common law system, stare decisis. That's the Latin term for to stand by things already decided or to stand by previous decisions. And what it means is if I have a case which allows me to prove that the court should follow this other decision in deciding my case, then I will win. So this is called precedent or authority, and it's a principle or rule established in a previous legal case that is either binding on or persuasive for a court or other tribunal when deciding subsequent cases with similar facts or issues. Okay, and you often hear the phrase, this case is on all fours, which means, for example, if a table is one leg is a little shorter than the other, it's not very stable. Okay, but if the table is stable, then it's good to use. Well, if a case is on all fours, which means is the facts and law are sufficiently proven and similar to the case at bar, then it becomes good precedent to use. Now, if Holden was suing Graham, and there was one case which supported me suing Graham, then we probably wouldn't wind up going to court because Graham's lawyer would know he's going to lose, and there's a rule at law that says you never go to court with a losing case. And so it would be decided. But because the cases aren't always on all fours, one case may help, but another case may help the other side as well. And so they all have to be brought into the court and argued. What can the courts do? Well, there's 5 things. They can apply, follow, consider, distinguish, or overrule cases. And let's say I'm suing Graham and it's in the BC Supreme Court in Vancouver, and I have a BC case which I think is on all fours, and it should help the judge decide in my favor. But Graham's lawyer has a case from Ontario, which comes from the Ontario Court of Appeal, which is a higher court than the BC Supreme Court. And he thinks that should be the applicable law. Because it's a higher court, and although not on all fours, it might help the situation. So our lawyers go in and they argue, they get the facts in, and then in their summations they argue the law, and that's when you bring in a precedent. So let's say the judge says, well, the Alberta court case is helpful, and I consider it. Or I, as helpful but not determinative, I think the BC case should be applied. So you apply the law of BC to the case and you get the result, right? But let's say the judge says, well, no, the BC case is not as good as the Alberta Court of Appeal case. Well, the judge cannot at that point say, I am going to apply the Alberta case, because you cannot apply the law of Alberta in BC. But because we're both common law jurisdictions and have very similar legal systems, we can follow the law of Alberta in BC. Okay, so that's the difference between applied and followed. let's say the judge looks at the BC case and looks at the Alberta Court of Appeal case and says, they are both helpful, but not determinative. In other words, they don't tell me what my answer should be. Then he can say, or she can say, I consider those cases and I make the following decision. Okay. But if the judge decided to follow the Alberta Court of Appeal case, then he has to distinguish the BC case. Distinguish means explain why it does not apply in this situation. Or vice versa, the judge wants to follow the BC case, then he or she must distinguish the the Alberta Court of Appeal decision. All right? Now, every once in a while, judges make mistakes. And there could be a BC Supreme Court decision that is just patently wrong. Or society has changed to the point where it should no longer apply. But it is precedent, and the judge would feel constrained to follow it or apply it unless he or she decides to overrule it, which means say that is bad law, it is no longer applicable, I'm creating new law. BC Supreme Court judge is very reluctant to do that because they would probably prefer to say I'm going to apply it even though I think it's wrong. I'm constrained to apply it, expecting that it would be appealed to the BC Court of Appeal, who could then overrule it. Or if the BC Court of Appeal had difficulty overruling it, they could say we follow the BC Supreme Court decision, and then they hope to kick it up to the Supreme Court of Canada, who would then overrule it. The Supreme Court of Canada, 9 judges. On a commercial matter, 5 of them would sit. So let's say that 5 judges make a decision and establish a precedent in a case, Smith versus Hughes, and it's wrongly decided. Well, those 5 judges would be very hesitant to say, oh, that's wrong, let's change it. And then say, oh, wait, no, that one's wrong too, let's change it. Oh, wait, no, that's wrong. Because if they keep doing that, then there's no consistency or predictability and the system would break down. So once a decision is made, it's very, very difficult to have it overruled. However, judges retire or pass away, and if the bench changes, then these next 5 judges will be not as reluctant to overturn a decision of the previous judges because, oh, they're wrong, but we're not, okay? I mean, you have to have a huge, huge ego to think that I'm making a decision and I'm always right. When I was at law school, I wrote an essay for one of my classes where I looked at Canadian decisions that were overruled by subsequent Supreme Courts. And in almost all of those, the judges had either retired or passed away, allowing the new judges to take a fresh look at a previous case. We had a Chief Justice of the Supreme Court, Madam Justice McLaughlin, who was an incredible judge. Fantastic. And rather than saying that the Supreme Court is there to apply the law, she thought the Supreme Court should help develop the law, which I think is a bit scary, but a better mind's a mine. Anyway, there was a decision that she thought was patently erroneous. 5 judges made the decision, 3 in favor, 2 opposed. So it becomes law, a 3-2 decision, but not a strong decision, okay? So another similar case came up to the Supreme Court of Canada, and she looked at that case and she said, that was wrong. I cannot tell the next 5 judges how to make their decision. but I can influence them. Now, of those 5, these 3 made the wrong decision, these 2 made the right decision, these have all retired or died, but this fellow is still here. And so when she appointed the 5 judges to hear the new case, surprise, surprise, this judge was one of the 5, and the appropriate decision was made. So she was very clever that way, because the Chief Justice of the Supreme Court is really nothing other than the person who arranges who sits on what cases. But Chief Justice McLaughlin saw her role as much stronger than that. Okay. So anyway, cases can be overruled, but very, very seldom. Now, the next slide is a picture of a doctor, Dr. Morgenthaler, and it's regarding abortion, and this is a hot topic in the United States, but in Canada it's settled law that women are, under certain circumstances, in control of their bodies and can decide whether or not to have an abortion. Well, that's a relatively new law. In the past, back in the, I think, early 70s, abortion was illegal. Dr. Morgenthaler broke the law when women came to him. In certain circumstances, he would perform abortions, and he was charged with murder. His defense was necessity. He felt that it was necessary to perform the abortion to save the life of his patient, the woman. The courts did not agree. He was convicted of murder and sent to jail. It subsequently became a political debate, and eventually we came to the conclusion that under certain circumstances abortions would be legal and that women should be in control of their bodies. And I'm pretty much sure that, well, I can't be sure, but I think that most people should agree with that. So he went to jail, and then after the government changed the law, he was let out, wasn't he? Because they changed the law. No, he remained in criminal jail until he came up for a parole. All right, he came up for parole, and then the judges or the parole officers said, "Well, okay, the law has changed, and if he had committed that act today, it would not be a crime." And so they paroled him, but he had to stay in jail because just because you change the law, it doesn't get applied retroactively. He passed away just a few years ago, and they posthumously gave him the Order of Canada. So they recognized the tremendous service that he had done for women in Canada after he died. It would have been really nice if they'd given him the medal during his lifetime, but I guess better late than never. Anyway, I put that picture in there because that's a perfect example of this concept of precedent and laws changing and everything like that. Back to Regina versus Dudley and Stevens, and then we'll be finished this section. In the lecture guide materials, and I do not have a copy because they are all at Capilano University and I am keeping my social distance in Gibsons, BC, there is a head note from Regina versus Dudley and Stevens. And not too long ago, now things are computerized, but not too long ago, if a decision was recorded in a legal journal, and then there was a subsequent decision that referred to it, either considered or distinguished or followed or whatever, the court librarians would actually pull the law reporting service off the shelf, open to the page of that decision, and in the margin, they would make a note that this case was considered in this case, and this case was distinguished in this case. And that happened with Regina versus Dudley and Stevens. It was actually used as precedent in at least 3 other cases. So if you go to that page in the lecture guide and open it up, you will see the head note of the case, and then the judgment follows right after, but I didn't put the judgment in. you'll see that just to the right of the headnote, the librarians made a notation. One of them was distinguished in Northern Ireland, I think, where now the argument in Regina versus Dudley and Stevens was these men had to kill the boy and eat his remains by necessity, the law of necessity, the survival of them depended on it. In Regina versus Dudley and Stevens, the judge said there is no law of necessity. Okay. Well, in that Northern Ireland case, they said there's no law of necessity, and it was distinguished. And then there's another reference in there about considered, where Regina versus Dudley and Stevens was actually considered as helpful in a decision. The one that I think is the most incredible is between the top and the bottom one, there's one about a Canadian case where Regina versus Dudley and Stevens was referred to as precedent. And it was in the Morgenthaler case, because Morgenthaler's defense was necessity. It was necessary for him to perform an abortion to save the life of the woman. So they looked at Regina versus Dudley and Stevens, and that decision was followed. Why followed and not applied? Because this is a Canadian case with Morgenthaler, and the Regina versus Dudley and Stevens was an English case, so we cannot apply it. We can only follow it. But they followed the law. They said, in Morgenthaler's case, there is no law of necessity, a defense of necessity. Therefore, his defense fails, and he's guilty of murder, and he went to jail. So you can see how a case as bizarre as Regina versus Dudley and Stevens can actually be used as precedent in subsequent cases. And that's the basis of the common law system. The textbook, the old textbook that we used to use, talked about consistency and predictability being better in Canadian cases. Not so. I think there's a danger in our system, and that is it's very difficult to find precedents. You can find the article in the civil code that applies, because bang, there it is, only one article and no cases to look at. I had a client who was sued in small claims court for running a contest promotion incorrectly, and the judge was very, very aggressively anti my client. My client was the defendant, and I was trying to defend him, and it was a marketing and advertising issue, and I went to Bob Mackay, who's the senior partner of my law firm, and I said, what's the law on this? And he said, there is no case law. And I thought, oh, wow, we're in real trouble here. On a different matter, I'm in the courthouse, I have a law textbook, and I'm going through it, and I'm looking for a certain page, and I'm just, fanning the pages, and I thought I saw the word contest, because that's the issue. And I went page by page by page, and I found a case in Saskatchewan on contest promotions that was absolutely in favor of my client's position in this small claims court. I copied it, I go in, the judge is very aggressively has a great deal of animosity towards my client. He wants to find in favor of the plaintiff who's suing, and it looked very bleak until we got to summations, and I said that I found this case, which also referenced another case, so I had two cases that said the judge here, before my client, had no jurisdiction to hear the case. And the judge was absolutely furious. He reserved judgment, came back a week later, and went up one side of my client and down the other side of my client, and then said, however, I have to dismiss a case against your client because I am bound by precedent. Precedent works. I found it by accident. My client didn't know that. He said, wow, what a great law firm you have there because you found this case and it defended us. I didn't say, oh yeah, but I found it by accident. Of course not. But, because I found it by accident, was a little unnerving. In We're Not a Bank, We're Better, I spent hours and hours and hours with my business assistant in the law library looking for precedent and fortunately found one. if I had not found that precedent, I think our client would have lost in that case. So precedent works. It's getting better because you can now go online and find computerized services and find these cases quicker and better. But it's still a little unnerving. Okay, now that's the concept of stare decisis, which is very applicable to the common law system. We've looked at the other systems, and that will be sufficient for this portion, and we will come back next class and talk about the Canadian Constitution. Thank you very much.